Welcome to the Agent's Angle, where everyone has probably heard those dreaded letters FFAR far too often over the last 2 years. But could all that be coming to an end in the not too distant future?
And this episode gives us one main court of call this week, and yes, you've guessed it. That is the hearing by the European Court of Justice regarding just one of the cases brought against FIFA and the FFAR.
But just when one dispute may be reaching some form of a conclusion, it seems there is yet another developing and coming more to the fore in the last week, that not just players but also agents need to be fully aware of.
All that to come on this episode of The Agent's Angle.
Yes, it's that episode or week that I think many in the agent world would have been waiting for. Well, at least since the ECJ, the European Court of Justice, said there would be a hearing regarding one of the complaints against FIFA and the FFAR. That was referred by the German courts back in 2023, I believe. And whilst the show we really want to do is that featuring a final verdict on the FFAR after many years of waiting, we're going to have to wait a bit longer for that following the hearings earlier this week on Wednesday. And that would seem to be the back end of 2025 as it stands. So the FFAR saga rumbles on, but May should give some idea of where the judgment will go, as that's when the Advocate General is said to be delivering their opinion on the matter.
Yes, Jonathan, I was actually disappointed we didn't get to see the ECJ in action live and look at councils submitting on behalf of FIFA, on behalf of the agencies, and we also know the German Football Association, or DFB I should say, was also represented as one of the defenders. It was two cases actually, but as you said with FFAR, the FIFA case was the second case in that matter. You mentioned the Advocate General. Stipulated on the 8th of May 2025 that there'll be an opinion on the questions referred to the court. And as we've seen in previous cases that affect FIFA, and we'll mention those cases later in the podcast, that is an important opinion.
I really just don't want to say those four letters almost every week, Peter. It's gotten to the point where it's become a permanent ringing in my ears. And to be quite honest, when we started doing the Agent's Angle, almost some 2 years ago now, the matter of FFAR was, and I think we will admit, one of the core motivators for bringing the podcast online. But we always wanted to cover more diverse topics on the world of football agents beyond something that has dragged on for far too long now, and somewhat unnecessarily in my opinion, to a point where it's almost become a farce, although not in the slightest bit funny for many of those affected.
Well, the cloud of FFAR has always been hanging over us since day one. But we've done our best. I mean, we've had guests, from Japan, Malaysia, South Africa, Morocco. I won't go into any more countries, but there's some of the countries outside of Europe that we've had guests from. And we've tried to mix that up, as we would say in Australia, with different guests, different topics, and also other tools that affect agents. But you're right. The transfer window just closed. Talking agent business on an agent podcast with an agent perspective is always better. Yet, the FFAR drives how Agents International will work. So we've had to spend a lot of time on it, but let's get on with it.
Yeah, you say it drives everything. I actually see the FFAR more as a wheel clamp on the industry. We haven't moved anywhere and we haven't got any further forward. If anything, we've gone backwards. But before we do start to look at the hearings relating to the FFAR at the ECJ, and we have a guest coming up to share his observations on that with us, there is another important story of a potential dispute brewing in football that in some ways is similar to the FFAR dispute, as it refers to an element of capping what people can earn. And it has been reportedly bubbling away for several months now. But I don't think it's really got the attention it deserves, as the details have been pretty thin on the ground for many, and some of it can be quite technical from a financial perspective. And to try to sum it up, this is the possibility of a cap, although not technically a hard cap, depending on who you speak to. And that's on player salaries, agent fees, and club spending in the English Premier League.
Yes, a very interesting development or topic, I would say. Salary cap plans in the EPL, English Premier League, and a lot of articles about this. New York Times has got articles, The Guardian's got articles about this. Now, before I start giving a bit of background to this, Jonathan, salary caps, admittingly, are not new to me, as we have them in the Australian A-League. So I'm pretty much aware of how salary caps work in terms of wages and how agents' fees are included in those salary caps. Yes, there are exceptions outside the salary cap, but we've worked with salary cap here for a decade or so. But to summarize these articles, as you mentioned, the PFA, the Professional Football Association, FIFA Pro Players Union based in England, has threatened legal action against the English Premier League over proposed salary cap rules. And what's that about? The Premier League is considering a hard salary cap based on multiple of revenue received by the team finishing at 20th in the table. So the bottom team. This is called the anchoring rule proposal to ensure a little bit about competitive balance, but this faces strong opposition. Manchester City and Manchester United, who are opposed to the cap, especially because of their ambition. They want to compete with European rivals in the European Champions League, etc. But let's go back to the PFA. What the PFA arguing against this proposed cap is proposed because it has to be passed. It hasn't been implemented. That the salary cap restricts free market competition and should be legally challenged. And they weren't obviously consulted on it. Now, we know that UEFA's got its financial sustainability regulations, which is 70% of revenue for teams in European competitions. And I want to do a comparative analysis, and I'll be brief here, but we know the NFL, the National Football League, and the NBA, Basketball League in America, have got strict salary caps and revenue sharing models. So it's interesting that they operate in that sort of environment. Yet maybe it's hard to make this comparison, as some of these articles suggest, because English football's got relegation, which doesn't exist in those leagues. Now, the key thing for agents is that the 85% of spending is total revenue on wages, transfer fees, and agent fees. So agent fees fall in that. So that's the important thing from the agent's perspective. But we don't know how it's going to go. And on my final point here, Jonathan, we have not heard anything from the agent associations read this cap. They have members in England, European Football Agent Association, Football Forum, ProFAR. And what's their view on salary caps? Because these type of salary caps include agent fees.
And the place that the broader football audience usually goes to first with this topic is player salaries. And to an extent, that's somewhat understandable. And I think it comes down to the old argument or question, are footballers paid too much? Some are arguably paid more than they're worth, not mentioning any names. But that's the same for some managers, some sporting directors, chief execs, and for that matter, agents. And those salaries of players are, of course, inextricably linked with agent service fees, as are transfer fees potentially when an agent provides services to a club. Although I think it's worth pointing out, these Premier League proposals refer directly to agent fees in the same breath as transfers and player wages, which I take as a bit of tired rhetoric, as agent fees generally fall as part of those other two factors anyway. But as usual, I come back to the point that when it comes down to negotiating contracts or a transfer, no one is being frog marched to the bank or held at gunpoint to pay that salary or transfer fee. Well, at least not in the confirmed stories anyway. And the topic of financial controls and sustainability regulations, whether it be anchoring, a soft cap, a hard cap, or whatever else, is such a rabbit hole of a topic. But from an agent's perspective, if we do see such cost controls as anchoring, it will, for me, firstly make agents' lives more complex, but also arguably make the role of agents more important and more valuable. Because as an agent, you will not only be considering a basic contract offer from a club for a client, but also new variables to look for in terms of knock-on effects relating to other players, clubs and agents, whilst also weighing up such things as to whether a club can honour an offer or in the longer term possibly renew or enhance a client's contract. But the big thing for me is something we have discussed several times in recent episodes of the Agents Angle, and that is the role of agents representing clubs, which, in light of more stringent cost controls, I think will further enhance the role of club agents in the capacity of offloading unwanted players for a club so that they can make room for somebody else.
Yes, I mean, that's an interesting perspective in terms of the club agents. And what we're seeing emerging is club agents v agents who specifically represent players. We're seeing that dichotomy, I think, recently. But I want to go back to the FFAR. The fee caps that were set up there actually strengthened that division. Now, obviously, those fee caps may go in the legal chunks that we'll discuss later, but there has been a dichotomy, and a lot of power now is with club agents. A lot of agents do prefer to be the preferred agent or have a mandate or a retainer with the club. This could also raise conflict of interest matters, but I won't go into that, Jonathan. I know it's one of your favorite topics, but that also permeates sometimes with club agents, especially under a salary cap environment. But for agents and for players, a salary cap changes the paradigm, the way agents work, because especially if it's a hard salary cap, dictate what clubs can offer. And when there's not that many jobs around, that could lessen the competition or the options for players in deals they take, Jonathan.
And there'll be a lot of commentary, as you said, about other leagues, other competitions, whether it be A League in Australia or the NFL or various other American sports. But the dynamics there are so different. You're dealing with collective bargaining agreements. They've been dealing with salary caps for so many years. You're looking here at English football, which is a totally different dynamic and been established in the way it is for so very, very long. But this particular case in itself, even if just one country, is an incredibly complicated scenario with so many different parties or stakeholders with key roles to play. Firstly, the PFA has obviously a key role here, as they were the ones reportedly threatening legal action before the meetings this week that saw the plans of this anchoring or semi-hard cap delayed. Yet, as well as reportedly having a certain Nick DeMarco, KC, warming up to fight their corner, a name that undoubtedly would make any football authority break out in a cold sweat, they also have a collective bargaining agreement that reportedly helped them in their case when the EFL, the English Football League, which is the level below the Premier League, tried to implement a cap on player salaries, which again involved Nick DeMarco. The FA is also important here, the Football Association in England, although they're not mentioned so much as of yet. They have a golden share, which could be crucial as to whether the Premier League would be allowed to implement a cap of any kind. And in an ideal world, as you rightly said, the agents would have a key role to play as well in this debate, as their income is directly affected by such a cap or anchoring mechanism. That is, if only we had a true representative voice in this case for agents.
Yes, I mean, you mentioned Nick DeMarco. He obviously has been involved in some of these cases and actually wrote a great analysis piece on salary caps. And I just want to summarize a little bit of that because it gives us a bit of the pros and cons. And I think agents need to understand that. And you mentioned this, the English Football League 1 and 2 had salary cap rules. They were challenged and they were scrapped. And the reason why these caps failed was they tried to limit spending, but it was a rushed implementation. No consulting with the PFA, Professional Football Association. PFA challenged the cap legally, arguing it violated trade union agreements, and they got a decision forcing the English Football League to scrap the cap. But Nick DeMarco goes further. He mentions that salary caps don't always work in football because of the economic and legal conditions which make enforcement difficult. You mentioned US sports, but US sports don't have promotion relegation systems, which clash with salary caps. Therefore, it's a closed league versus an open competition, which the English Premier League is. So how do you enforce salary caps? Anchoring maybe is a concept that may be able to work, or squad cost ratios, but these are complicated financial arrangements. And when you put a salary cap, there's a lot of nuance in that. And the other thing is successful salary caps have an equal revenue distribution, and that is not the case in football. This is what Nick DeMarco argues. But Nick DeMarco dissected that the caps may limit players' wages, and this is important for agents, while clubs can still profit from transfer fees. That's very, very important.
And to sum it up, I think it all boils down to two things. One, limiting what someone can earn, and two, implementing something without meaningful consultation. Sound familiar? And with that and the broader topic of capping, there is only one direction of travel for us now on this episode of the Agents Angle, and that is to look at the hearings at the ECJ just a few days ago. But before we start, I think it only right we make a quick apology. As according to our sources, some of whom are pretty close to the cases, the hearing on FFAR from the ECJ was going to be streamed online. But in the end, that didn't happen. So if, like us, you were clicking the refresh button many times on Wednesday, apologies, but you weren't the only ones. Although in hindsight, the signs were there that it wouldn't be the case of being a public streaming, as the hearings don't seem to have been held in one of the main chambers and were at different times of the day. And there were two hearings on Wednesday. The one in the afternoon, which was the one with FIFA and the FFAR as defendants, and then the one in the morning, which is more of a case relating indirectly to FIFA and the FFAR. So, Peter, do you just want to give a quick recap of those two cases?
Yes, unfortunately, we didn't get to view any of the cases on the streaming service, which was disappointing. But there are two cases here. And one is, I'll go for the first one, which is Rogon and MVI Management. They're the applicants or appellants. And the defender is the Deutsche Football Bund, or the DFB, the German Football Association. And that first case concerns the interpretation of an Article 101 of the TFEU, which prohibits anti-competitive agreements. In other words, cartels. So there's two questions, and I don't want to get too complicated here. There's a famous EU case called Medina. It's a test you apply to a sports association like the German Football Association's regulations that affect competition. And what this test looks at, so the court will look at it simply and say, what's the context of this regulation, the objective? And will this regulation restrict competition, or is it proportionate? Now, what regulations are we talking about in this first case, the Rogon case? It's not so much about the cap. It's rules under Article 12.8 and 9 of the FFAR FIFA Football Agents Regulations. And what are those rules? I mean, amongst other things that are in this case, that a football agent may only perform football agent services as one party in the transaction. We know there's only one sole exception in permitted dual representation. It really is about the German rules, the EU competition, how it applies to those rules, and whether those rules impact market competition. I move into the second case, which is RRC Sports versus FIFA. And I think this is one that we're all looking at as agents and even sports lawyers. And I won't go too technical because we've got to have our guest who's going to go into some of the articles. But whether the FFAR is structured in a way where it affects competition, and we know the EU rules prohibit cartels, prohibit organisation of abuse of a dominant position. So whoever's the regulator or the federation, in this case FIFA, can't abuse a dominant position. The core question, and our guest will go through this, is whether the EU laws preclude FIFA from enforcing rules on its federations that are binding, but also clubs, players, but agents in our case. And I'll just go into a couple of FFAR rules and related regulations, just in point form, what's under scrutiny in this case. The agent remuneration cap, the third-party payment prohibition, club payment limits, licensing, which is a big one. So we're talking about the football agent's license. And I won't go into them all. Cooperation restrictions, where agents are prohibited from engaging with clubs or players with exclusive agreements with other agents. That's an interesting one. Transparency arrangements. This relates back to the information that agents upload on the FIFA platform. That's more those general privacy prohibitions. So this is a very mixed case, Jonathan. I won't go into any more, But you get my point how this case will affect going forward the FFAR and agents. One last point. It also challenges the disclosure obligations of agents, which requires timely disclosure of agreements, payments, and any cooperative arrangements involving player agents. We all know from the FFAR, there's also that connected agent thing. Don't know if this case affects it, but it may. But this is a case where a lot of areas are attacked, not just FFAR, but the privacy and information sharing, Jonathan. So that's the two cases. I hope I have able to break it down a little bit and what provisions are being challenged that affect Asians, especially against FIFA, but also the German FA, Jonathan.
And of course, the various legal battles and challenges to FIFA and the FFAR have sparked intense debate from all sides. And with such a set of polarised views between FIFA and the agent regulations, we felt it crucial to bring you a largely independent and objective legal perspective on the ECJ cases heard earlier this week, as well as the many cases that may have more of an indirect effect on agent-related affairs. So today we're delighted to welcome Gianluca Medina to the Agents Angle. As a highly respected sports lawyer at Legislab, Gianluca brings extensive experience in football law, regulatory matters and international sports governance. And he has emerged as a leading voice on FFAR developments and football agent regulations, both in Italy and internationally. His reputation for delivering clear, balanced analysis on what has become a highly politicised football regulatory topic makes him a perfect guest to help us all understand these developments and the possible ramifications. As such, it will be interesting to hear his observations from the various cases and thus understand the broader implications for agents and football as a whole, and getting his insight on what might come to pass in yet another landmark case involving FIFA. Gianluca, welcome to the show.
Thank you so much for inviting me.
Now, before we step into the realms of the FFAR hearing at the ECJ, there is one area where your expertise is so important, and that is the Italian football agent regulations. Is it still the case in Italy that there is no update to the introduction of new Italian national football agent regulations, as these have been in a development phase for an extended period now, as I understand it? And with Italy being a key football nation and market, this is important to many agents and others in football. So with that in mind, can you give us a quick update on the situation in Italy with those national regulations and what may be the cause of the delay? Could it be a case that the FIGC may also be waiting for the FFAR outcomes at the ECJ?
Well, long story short, there are no relevant updates to the introduction of new Italian national football agent regulation as far as you expect it to be compliant with the FFAR. I think that you're already well aware of the situation around the regulatory framework about football agents in Italy is quite problematic, to say the least. As you know, Italy is one of those countries having from 2018 a national law licensing system for professional sports agents with a double track licensing, registration, and regulatory system. So the one before the Italian National Olympic Committee and the related sports association. And actually in 2021, within the wider legal framework of the sports reform regarding several aspects of the sports legislation in Italy, a new legislative decree governing professional sports agents was issued, also reshaping certain aspects of the matter. However, for the detail of certain provisions, such a legislative decree dedicated for an implementing the decree, which unfortunately has not been implemented yet. And this issue has been putting the Italian Football Association in a not desirable position, let me say, as any issuance of a national football agent regulations in compliance with the FFAR would have been and would be inconsistent with the expected new legislative framework. And actually, in terms of updates, on 28 September 2023, so 2 days before the deadline imposed by the FFAR for national football agent regulation, as you know, the Italian Football Association Federal Council announced to have implemented the fundamental principle of the FFAR, subject to further discussion amongst the stakeholders. And afterwards, on 1st of October 2024, a further announcement was made for the approval of a new version of the National Football Agent Regulations, taking into account the so-called suspended FFAR rules as per Circular 1873. However, and this is the most important part, such a regulation were never published by the Italian Football Association, so the FIGC, and we are still under the FIGC sports regulation issued on February 2022. So this is, generally speaking, the framework, and as you understand, is quite problematic.
We were all waiting to see live these two German referral cases that went to the European Court of Justice. Disappointingly, we didn't get any vision or any streaming. So a lot of what we know about these cases or what was submitted is subject to speculation. But we did see the submissions. I know there was two posted of the submissions, two cases. And I want to talk about the first case, firstly, in terms of the European Court of Justice hearings this last week. The Rogon case, Rogon being one of the big German agencies versus the DFB, which is the German Football Association. This case primarily concerns the interpretation of Article 101 of the Treaty on the Functioning of European Union, which is shorthand TFEU, which prohibits anti-competitive agreements or cartel agreements within the European Union. How do you see the outcome of this case, which may clarify how EU competition law applies to football agent rules set by sports associations like the DFB that may impact market competition going forward?
It is important to underline, as you said, that the request for a preliminary ruling in this case is related to German football agent regulations, and preliminary ruling just follow several stages of local German courts discussing about this topic. And we are now getting to the final stage of these German proceedings, let me say. However, the contents of this preliminary ruling touch one of the core issues regarding the assessment under EU competition law for football agent regulatory, generally speaking. And that, in my opinion, will also be the focus of the second preliminary ruling, so the one related to FFAR. So, in short, and without getting into details, the question here is if and how the so-called Medina test may be applicable to the related football agents regulations. And again, in short, what is the Medina test, or the so-called three-stage test, according to which, very generally speaking, a cartel decision may be justified whether the cartel decision itself pursue, one, a legitimate interest, two, is necessary for achieving a legitimate object or interest, let's say, and the cartel decision is proportionate to those objectives. So, for those who are familiar with the several legal challenges worldwide against the FFAR, and also with the documentation that FIFA has so far issued related to the objectives and the rationale behind the FFAR, and also to Circular 1873 itself, it is quite evident that FIFA truly relies, among the others, on such principles, and generally speaking, in the chance that ECJ will apply the Medina exception to the contested rules. And again, I don't want to get into details because there are several issues under EU law which are behind the interpretation of Medina test exception on so many levels. But the fact that the ECJ is expected to provide an interpretation on if and how such exception would be applicable will truly stand, in my opinion, as a landmark decision that can clarify, generally speaking, some issues, and in particular, EU competition law being applicable to the FFAR. So this is my view on this case.
That's interesting because there's also a second case being the FT and RECC sports versus FIFA. And this is one that interests a lot of us outside the EU. And we know that this case hits at the heart of the FFAR because it's FIFA who's, I would call, the respondent or the defendant. The way I understand it, the core question of this case is whether the European laws preclude FIFA from enforcing rules binding on its 211 national federations and therefore on clubs, players, and of course, what our podcast is about, football agents. How do you see this case, the case against FIFA, impacting key FIFA rules that are under scrutiny from the FFAR? For example, agent remuneration cap, third-party payment prohibition, also some licensing requirements. What are your observations about what impact this may have on the FFAR, Gianluca?
Well, I think that everyone involved in the football agency industry has understood the importance of this preliminary ruling in the context of FIFA's attempt to establishing a new era of regulating agents by the FFAR. So I think all know that by Circular 1873, FIFA decided to suspend certain FFAR provisions which were affected by the Dortmund injunction, but on a temporary basis, until the ECJ renders a final decision in the pending procedure concerning the FAR. Also, in this case, in my opinion, it is important to try to focus on certain basic technicalities without getting into details, and in particular, to consider the question referred by the Minds Court to the ECJ in this case. So, first of all, the FFAR rules, and as you said, also other FIFA rules are involved in these proceedings, which are under assessments and are quoted in the questions, have been divided into 13 rules and cover a wide range of provisions. We will not mention all of them, of course. And on the other side, what are the EU laws under the ECJ interpretation, which may precluding the above-mentioned FFAR rules? So, as you can see, the EU laws in this case are wider than the Rogon case and are the entire Article 101, Article 102 of the TFEU, so the prohibition on abuse of dominant position, and Article 56 about freedom to provide services, and also Article 6 of the GDPR. So we have a wide range of provisions. And this is also clearly shows that, similar to Diarra, not only competition law is involved in this case. Amongst the other, one of the focus will be also in the case about if and how the Medina test may be applicable. However, the chance of the applicability of the exceptional rule may be another core part of the preliminary ruling, and in the past, in the PO case, the ECJ in a certain way assessed the compatibility with the European Union competition law of the 2001 player agents regulations. So again, in short, and not taking into account the different technicalities behind such proceedings and the one of the case at hand, ECJ considered such exception being applicable regarding the licensing system. On the other hand, it is important to stress that reportedly the referring court, the Minds Court, takes the view that it's not evident that the strict requirements laid down in Article 101, paragraph 3 are fulfilled in the present case. So there might be different visions on paragraph 3, but coming back to the ifs and hows regarding Medina, and we already mentioned the complicated aspects behind such issues, it is important to mention that the recent ECJ ruling regarding the Super League and the R case that were taken after the request of preliminary ruling made by the Minds Court added another element, which, according to many EU law experts, may have an impact on the case. In fact, try to keep it simple, Super League and the R case have given a certain interpretation, which has been harshly criticized by many in terms of narrowing the scope of applicability of the Medina test. And should the ECJ consider, generally speaking, that the affected FFAR rules are a restriction by object and follow the Super League and Diarra case interpretation in this respect, such test would be a failure of the FFAR rules. Again, we are just touching a single part of the problem within several obstacles and several issues that are behind this case. And we are only talking about EU competition law, that is just one aspect of the proceeding, generally speaking.
Yes, having a look at those submissions for the RRC Sports v FIFA case, there's a lot of areas it covers, including, I would say, matters that don't relate to FFAR and more relate maybe to even privacy and things like that. So it's going to be very interesting how the court comes to a decision on a lot of those aspects. However, in terms of the agents, and a lot of agents are concerned that FIFA is regulating us, but we're not actually stakeholders, or we're not members. And one of the crucial questions in terms of from the agent's perspective before the ECJ, in both agents' case that we mentioned before, both German referrals, is this question. A governing body or football association or even a league be allowed to regulate players' agents, capping their fees and limiting their activities, even if they're not members of the governing body? Would you say that this is an accurate representation? And what is your view on the question of how the ECJ will possibly view it, considering agents are not really members or stakeholders of the governing body? And the only real avenue they have at this stage is, we've talked about this before in our podcast, is the FIFA Agents Working Group. How do you see this question and how the ECJ will deal with it?
Well, generally speaking, I truly believe that the issue relating FIFA's legitimacy to regulate the football agent matter is maybe one of the most controversial part relating to the FFAR regulatory framework. And as you know, the July 2023 CAS award, which has been criticized by so many, did provide for an answer to this question. And in short, and in view of the CAS panel, such question was left open, and the panel, in a certain way, endorsed the technical and democratic legitimacy. However, as I said, the ECJ preliminary ruling will follow the path that was prepared by the referring court, and in particular, ECJ is expected to provide for an interpretation of the already mentioned EU laws and how they may preclude the contested FFAR rules. And we can say that, coming back to the CAS award, it is true that the PO case left an open question. On the other hand, we can also say that there are also certain paragraphs that, according to scholars, were considered enigmatic, that also give a wider view on the matter. And I'm quoting when, in the PO case, the European Union Court said that, in principle, such regulation, which constitutes policing of an economic activities and touches on fundamental freedoms, falls within the competence of the public authority. And again, that the very principle of regulation of an economic activity concerning neither the specific nature of sports nor the freedom of internal organization of sports association by a private law body like FIFA, which has not been delegated any such power by a public authority, cannot from the outset be regarded as compatible, in particular with regard to respect civil and economic issues. On the other side, nowadays we can say that FIFA does think that during the process it found certain endorsement by at least the EU institution, as we said. And generally speaking, even though those paragraphs really sound as criticizing the legitimacy of FIFA about football agent matters, on the other hand, we do know that the PO case, generally speaking, provided only a EU competition law assessment, howsoever, and did provide a sort of green light on the player agent regulation 2001. So this is a very, very critical point, and maybe the most important part, again, from a political perspective, but maybe CJ can restart from such observation and give their view on this point. However, let me say once again that the decision itself will be made according to the preliminary ruling, but based on a specific set of rules regarding EU law interpretation applicable in this case.
Yes, there's a lot to consider. I'm going to open up the next question, Gianluca, just with some context. Super League, European Super League, the Diarra case, and we recently had the FC Seraing case. Huge cases that in effect affect FIFA, but also agents. And why I raise that, because we are an agent podcast. So if Super League takes off, big deals, agents are very interested in that. The Diarra case, when you're negotiating terminations or contracts, very important aspect of a contract are the termination, unilateral or otherwise provisions. FC Seraing, we talk about jurisdiction. Right now, the agents chamber doesn't exist. There have been CAS cases for agents, but we know the Seraing case may change the landscape. After that introduction, I want to get into the question now. You mentioned the Super League and you mentioned the Diarra case in a previous question, may have a bit of an impact on the ruling regarding the FFAR. And that wasn't enough for FIFA to contend with. There is, as I've just mentioned, the impact of the FC Seraing case, which I'll just elaborate on, where the Advocate General held that the CAS awards must be subject to full review by national courts in member states on questions of EU law. That's not a final decision. We've still got to get the decision from the ECJ, but we know the Advocate General opinions are very strong. What impact do you think, Gianluca, these cases will have on FIFA regulations and CAS decisions? And do you think it will influence the ECJ decisions in the two agents' cases that we've just suggested? Not least because FIFA had quite publicly and repeatedly held up the Profa v FIFA case at the Court of Arbitration on Sport, which went in FIFA's favour on the FFAR in defending their stance or elaborating on their points on why they think the FFAR is fair and relying on that in terms of their position. So what do you think these ECJ decisions, the three that I've mentioned, Super League, Seraing, and of course, Diarra, which has had a lot of news lately, will influence the ECJ decisions in the agents' cases?
Well, it's important to understand that the core of the matter about the regulations of sports agent has so many particular aspects to be considered that a comparison should be made only on a general basis and how certain part of those decisions can have an impact. As I said, Super League and Diarra case set for a certain interpretation of the Medina test that, according to many experts, may have a problematic impact on the view that FIFA also has, in my opinion, of the Medina test. But everything is open to next steps, and let's see how that will come from the decision. Regarding the Seraing case, as you said, we are on a stage of an advocate general opinion, and the consequences which may rise from an ECJ decision following the grounds of the proposal set forth by the Advocate General may have an impact to the whole FIFA dispute resolution process, in my opinion, and more in general to mandatory sports arbitration. Not in the way that maybe the Super League and the other case may have in terms of the Medina test.
Now, Gianluca, we can't close without a final word on FFAR. And from me, from a non-legal perspective, and probably a lot of people who don't have that legal foundation, they're probably asking similar questions. And I'm not going to ask you to accurately predict the outcome of the FFAR. Nobody can accurately predict that. But I have two questions for you just to close. Firstly, in a few words, what do you think will be the outcome of the FFAR case, as well as an approximate timeline in regards to the ECJ? Like, obviously, we've had the hearings, we'll have the opinion, then we'll have the decision. And secondly, given that we're now facing yet another wait, do you think FIFA may soften their stance in any way, given all these challenges and the mounting pressure from the various rulings, not just at the ECJ, but from all around the world?
Well, let's start with the easy answers. So the fact that we had some news about the dates when the Advocate General will provide opinions on the cases, it is expected to be on the beginning of May. And if we make a comparison with the timing of the Diarra case, where the Advocate General opinion was dated 30th of April and decision was dated 4th of October, we might expect a decision on the FFAR in maybe the first phase of the next sporting season with a, let's say, margin of error of a couple of months. This is what so many experts are telling us about this part, so the timing. So regarding the possible outcome of the FFAR case, of course, no one can precisely predict the outcome. However, there are some points on it that we can consider. In my opinion, it is quite evident that at the moment, by way of Circular 1873, so the suspension of certain FFAR rules, it is clear that different legal challenges have already put FIFA in the position maybe to reconsider most of the main pillars of the FFAR reform. And above all, the rules concerning the service fee cap provisions, though that is made on a temporary basis, because FIFA is waiting for ECJ final words, and in the context of what is the history behind FIFA rules compatibility with the EU laws, this is very well part of the process, let me say. However, again, without getting into details, staying on a high level, should ECJ follow the grounds which emerge from certain parts of the publicly available documents regarding the request of a preliminary ruling? And just to make an example, it sounds quite clear that the Medina test would lead to a negative result for what concerns the service fee cap provisions, and the contested FFAR rules may not survive the ECJ provisions. On the other hand, the political process which brought FIFA to launch the FFAR reform took so many years, and I truly think that FIFA put a strong effort in assessing a defensive strategy, if we talk from the football agent's point of view, to say it very clearly. Most importantly, even though it is soft law, and we already said that, FIFA has effectively found a certain endorsement also by the EU institutions in a certain way, and we can read that the European Parliament recalls the need to regulate the activities of agents and acknowledge that the recent reform in football transfer market, including the establishing of a clearinghouse, licensing requirements for agents, and caps on agent commissions, go into the right direction. These are not FIFA words, but are EU institutions' words. And if we also make a comparison to the legitimacy that the 2001 Players Agent Regulation had from the PO case at least for reintroducing a licensing system, we can say that FIFA attempt to re-regulate football agents may not completely be ungrounded, let's say. However, it's one thing having a certain degree of political backup from EU political institutions. It's another thing to survive the stress test that ECJ will make to the FFAR regulatory framework. And as far as I can tell from a political point of view, there are also some issues that, in my opinion, regards the points of view of agents about the football regulatory framework matter. First of all, maybe we can all agree that all category of agents provided for some observation against the rules regarding the mandatory service fee cap. On the other hand, I'm not that sure that there is a complete alignment in the opinions regarding the introduction of a worldwide licensing system, which may allow football agents to be legitimized to operate worldwide, and according to a certain degree of ethical standard and qualifications that FIFA has spotted as an objective to be pursued, generally speaking. After all, this has been the rule for so many years before the FIFA deregulations. And therefore, I truly believe that among the different aspects of the FFAR reform, there might be some substantial differences from the football agent perspective, also on a political level. And maybe we are already living in the future according to the rules that have been suspended by Circular 1873. But as we said, there is an important point, even more important to what we have said so far about rules and the view of football agents on the views. That is the legitimacy issue about FIFA regulating football agents as such. And this is the most critical point of them all under a political perspective. And this is, at the very end of the day, related to the complicated relationship between state law and sports regulatory autonomy. Just making a practical example, as far as one country, such as Italy, takes a legit political decision to regulate the matter under national law, also in terms of licensing system, so raising the standard of regulation to something similar to other professions, such as lawyers, for example, which does not acknowledge the licensing system issued by FIFA. While the other way around, the FFAR recognized national law licensing system in principle. In my opinion, the efforts that FIFA may have been implemented to pursue the worldwide harmonization of the matter, that can be also an opinion shared by some agents, this would substantially fail. So time will tell, in my opinion, if we are going back to the future to a mechanism similar to 2001 player agent regulation, or whether the political process and legal challenges and developments, generally speaking, will make once again FIFA to force a step back. Time will tell, but I think that today we try to touch just some points of the issues. And again, time will tell, and we will wait for the developments.
Time will tell. And as I think I wrote most recently, this is probably the end of the beginning, or the beginning of the end. There's a long way to go. But Gianluca, thank you so much for your insights and observations on the FFAR cases and the knock-on effects of those other cases that have an impact. And we'll all no doubt be watching with great interest for first the opinion of the Advocate General and then eventually the ruling, although we're possibly going to have to wait another 9 to 12 months for the latter. And as we've spoken about today, the impact of the ruling could extend well beyond this case of FFAR, not least in Italy, where, as we know, developments on football agent regulations have long been anticipated. But it's been a genuine pleasure having you with us today on the Agents Angle, and we're deeply grateful for your time. So thank you very much for joining us.
Thank you so much, Jonathan and Peter, for your time.
Well, all we can do now is wait for the opinion, which is reported to be on the 8th of May 2025. Maybe it'll be an early birthday present for me to celebrate a few days later. And then the judgment or ruling possibly several months after that. We'll have to wait to see if either of those trigger a change of direction or change of heart from FIFA in terms of the FFAR. If defeated, will FIFA appeal, or can they appeal? And how long will that take? Will FIFA carry on regardless in territories where an ECJ ruling will have no effect? Will FIFA stick with a threadbare set of regulations, if only to profit from licensing, exam fees and agent CPD? Or will FIFA scrap FFAR and metaphorically take their ball home, leaving a worse mess behind than what was there before and the one they have created since? And if FIFA do win, will FIFA change anything or just carry on regardless? How quickly will FIFA reintroduce suspended elements of the FFAR? And then how will they enforce them? Plus the national associations, as many of those will have to do the same. What about the territories where rulings have already been passed and parts of the FFAR are unenforceable, such as England and Brazil? And those territories where we can safely say things are on hold to see what the ECJ decision is, in the hope it saves them time with legal complications. And I think Australia is one and China another. But from what we have heard, there is absolutely no signs of FIFA softening its stance on the matter of FFAR at either of these hearings or elsewhere.
Yes, right now, I think FIFA are keeping the same position. I just want to go back to our guest, Gianluca Medina, Jonathan. A very passionate sports lawyer, grasped and dissected this issue very well. It's not easy to summarize legal cases that are being heard, especially when you don't even have the video or streaming footage. But very measured, highlighted the intricacies, I would say, and the complexity. It was a very interesting guest conversation. Now, in terms of FIFA stance that you mentioned, maybe the FIFA agent working groups know more about this than we do. And if I can say something here, that you're right. You mentioned England, Brazil, Australia, China. Even if FIFA get up on most of the FFAR, each country has got its own national rules, which make the whole ecosystem very difficult. And you just have to understand that even if the FFAR, a lot of the suspended provisions come back, and very interesting what happens to the caps, those caps are not going to apply in every country. So in a way, it's going to be very disjointed, an FFAR, regardless of the results. And certain agents, depending which market you're in. I mean, the Premier League, we know that's a $7 billion turnover league in terms of revenue. Obviously, with the Rule K arbitration, agent fees, there's no caps. We haven't mentioned this for a long time, but there's a Spanish challenge, and we know La Liga is a $5 billion league. Germany, where the two cases are, $4.4 billion league in terms of turnover. And then I won't go into Seraing and League One, but it's going to be very spasmodic. And I'm hoping that we get a model that works for everyone as an outcome from especially these two ECJ cases, Jonathan.
Whatever the ruling is from the ECJ, I just hope people actually wake up, take some responsibility and sort things out, because even after a decision I can foresee even more mess and confusion if people don't act in a coherent and constructive way on this matter.
I agree. It's time for resolution for all parties' benefit. Now, Jonathan, I'm going to ask you a question before I close. And this is a quote from an Italian agent, Alessandro Lucci of the World Soccer Agency. He once stated that today, we don't speak any longer about the agent, but rather the agency. And this is my question to you. I know it's off the cuff. Do you think this is a true representation of the football agents landscape today, considering Mr. Lucci's quote I've just said?
I think it is, but in so many different ways. Because it's true, and we've discussed this before. Rafaela Pimenta on a past episode spoke about it's not so much now that a small team or an agent on their own can represent players and so on and so forth. There's far more to that. I think it can be done, that an individual agent or a small agency can survive, but they need a lot of luck along the way. But the other side of it is that we hear people speak more about agency at the moment because the bigger agencies, I would dare say, control the narrative a bit more through the media, that they have more influence because they control the affairs of more players, so they can leverage that. But it's a big concern for me because we're going through an age now of the mega agencies and how much they control and how many different branches. And we talk about connected agents and the control on that. And I think we could get to the point where you've got multi-club ownership, and we've now got MAGs with multi-agency groups. And the interconnection between those is quite scary as well, because if you've got multi-club ownership, that people are fearing there'll be a skewing of the competitive balance and manipulation of competitions, When you combine that with multi-agency groups, if you've got a crossover between multi-club ownership and multi-agency groups, how much of that is a threat to the transfer market? And as a knock-on effect of that, a threat to the actual competition, whether it be federation competitions, national competitions, or even world competitions.
Yes, and we also mentioned the club agent v football player agent dichotomy. So very interesting to see what happens in the agency space always. Now, before I say farewell, I have one announcement, and that is there's a conference on sports regulation in Europe. It's organized by the Católica Global School of Law in Lisbon on the 22nd of February. It will focus on sports regulation in Europe. It's an interesting conference in the sense that it'll discuss the roles of the European Union, UEFA, FIFA in sports governance, and even the European leagues will be involved. And obviously, we've talked about the cases here today. So that's an interesting conference. Thank you, everyone, for listening. Please look at our socials, especially LinkedIn. We do polls, share those. We're open to suggestions for topics and guests that you'd like to hear, and we do value your opinions. So please get in touch. Bye from me.
And however much we welcome a final ruling from the ECJ on the whole FFAR affair, and maybe some clarity in the end, just maybe they will allow us to draw breath before the next episode of The Agent's Angle. So until then, take care and bye for now.
The purpose of the Agent's Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.